Well, thank you very much for being with us in this segment of Tu Comunidad, in English, Your Community. In this segment, we have Mr. Jeff Dillman. Thank you, Mr. Dillman. Jeff, for being with us. He is the co-director, correct, of the North Carolina Fair Housing Project, based of Legal Aid of North Carolina. He's based in Raleigh, so he came to visit us for this segment. Thank you very much, Jeff.
Thank you.
We're going to be talking briefly about the criminal background guidance that HUD, the Housing and Urban Development, issued recently regarding these transactions. Now, briefly, I would like just to say, Jeff, before you delve into the subject, that now it is possible, correct? If someone has a criminal background and because of that he's denied housing, he could potentially file a fair housing complaint, correct?
It is possible in certain circumstances.
Okay, so let's delve into the details. What people that have renters that have a criminal background, what it is that they should be looking for when they apply to try to rent a house?
Well, what HUD has said is that landlords and property managers have some legitimate uses for doing criminal background or criminal history screening. But in doing that, they can't be too broad. They can't apply the policies as a sort of a blanket policy to keep out everyone with a criminal history. And the reason is that doing so could be discriminatory under the Fair Housing Act. So specifically what HUD said is, when you look at why landlords want to look at criminal history of tenants, they're usually looking at things like, is this person going to be a potential danger to other tenants or might possibly destroy or damage property? And in doing that, it's important for landlords to look not just at whether someone has a record, but to look at the specifics of the record. For example, HUD said that if a landlord bases a determination on an arrest only without a conviction of someone, that can be discriminatory. The reason is because certain groups, African Americans, Latinos, people with disabilities, are arrested more than other groups. And so by using the determination of just having an arrest, that's going to have a discriminatory effect. So landlords shouldn't be making decisions based solely on the fact that someone was arrested. Now, if someone was convicted of a crime, a landlord can consider that. But again, they can't make a blanket policy and say no one who's been convicted of a crime can be a tenant. They have to look at several different factors. They have to look at the nature of the offense, how serious was it, and when did it occur? So, for example, someone who has very recently committed a very violent crime is in a much different situation than someone 20 years ago who was convicted of a very minor crime, right? Of stealing a loaf of bread or writing a bad check. That person who has a crime that was some time ago, that was nonviolent, that wasn't very serious, there's more reasons to give that person a second chance than someone who has just recently been convicted of something that's a much more serious offense.
Okay, wonderful. So for those who are watching, if they know that they have a criminal record, the guidance will try to make a distinction, or the landlord in the rejection has to make a distinction between the convictions and the arrests, correct?
Yes, the landlord should be making that distinction. Now, if someone is attempting to apply for housing and they're turned down, they should ask the provider, why are they being turned down? And if the landlord is using some sort of criminal background screening service, which a lot of them do, they generally should be providing a copy of the results of that. Some of those background services get inaccurate information. There's mistakes that are in people's criminal histories. It could be that they're listing offenses that the person was never convicted of. It could be some other person and their name is similar and their records sort of got mixed together. We've seen cases like that in legal aid where someone had offenses from someone else's criminal background on their own history. And so if the landlord is just looking at this one document and not giving someone an opportunity to say, oh, that's not me, let me prove that to you, let me show you that that's not me, it could result in someone being denied unfairly.
I see. So that's what people with a criminal record has to have in mind, that they could potentially ask for the copy of whatever it is that the landlord based the rejection on, correct?
Yes, they should ask for that.
So they can have an opportunity to potentially say, I didn't do it, this is someone that is not me, I didn't do it, or if it happened many, many years ago, that could also be the argument, correct?
Right, yes.
Now, for those who are landlords watching this,
Mhm.
is there any general guidance that we can give them, Jeff?
Well, I think it's important that landlords understand what HUD's policy is. And HUD came out with a very detailed policy position in April of 2016. We have that on our website. If people go to fairhousingnc.org, they can see a copy of the HUD guidance and make sure that they understand that. Landlords should know that while they can use criminal history of prospective tenants in making their decisions, they can't have blanket policies, and they shouldn't be making decisions based solely upon arrests. And so it's important that they look at that they look very carefully and see, okay, what have they been doing in the past? Have they been complying with the law? And if not, make sure that they get into compliance with the law.
Thank you, Jeff. Now, for those who have been convicted of sexual type of assaults,
Right.
is that different, or it's still they will be protected by this guidance?
Well, the HUD guidance is broad, and so it covers all types of offenses. And the nature of a particular sexual offense will vary. Some sexual offenses are relatively minor, and some are obviously much, much more serious. And HUD is very clear that if someone's tenancy were to pose a danger to other tenants, or would potentially result in the destruction or damage of property, then a landlord is permitted to refuse to rent to that person. If they are dangerous or would have a history of damaging property, that's a valid reason to make a determination. What's important is to not just look at a simple label of saying, oh, someone has been arrested or someone has a conviction, and use that as the full basis for it. The landlords need to look more deeply at someone's criminal history before they make that determination.
I see. And just to summarize, for that same purpose, those who have a criminal record or criminal guidance should not assume that it's going to be completely disregarded when they are applying to rent. It can still be used against them or to deny them housing, but there has to be some analysis behind the rejection, correct?
Yes, correct. Yeah, people shouldn't expect that if they've been convicted of a crime in the past that after a certain number of years automatically they're going to be able to get housing. However, if someone does have a criminal history, they can think about ways to try to present themselves more favorably. If they have employment and they have a letter from their employer that shows that they are responsible, if they have letters from religious officials, if they're involved in a religion, if they have letters from neighbors or other people who are respected in the community who can attest to their good behavior, then I think that's something that they may want to consider trying to speak to people about so that they can offer that to a landlord or a property manager if there is some concern about their criminal history.
Thank you, Jeff.
One other thing I will point out is that sometimes people's criminal history might be related to a disability. And so if that's the case, then people can ask for a reasonable accommodation that the landlord not consider it. So for example, if someone had a disability that sometimes made them act out if they weren't under treatment, and as a result, they were arrested and then convicted of disorderly conduct or something like that, if the arrest and conviction is based on this behavior that comes from their disability, they can ask for an accommodation and have that not be considered against them in renting an apartment.
Okay, wonderful. Well, thank you, Jeff. Mr. Jeff Dillman, he is the co-director of the North NC Fair Housing Project for Legal Aid of North Carolina. Thank you for being with us. And you heard it, folks, if you have criminal history, the guidance doesn't say that that will be disregarded, but it will offer some protections based on what Mr. Dillman already said about the severity of the crime, how long ago it happened, and those considerations. And remember also that you can file a complaint here in Winston-Salem in the Human Relations Department. We are tasked with investigating those complaints. Thank you, Mr. Dillman, for your time, and thank you for watching this edition of Tu Comunidad, Your Community in English.